Syllabus base for the 2026 bar examinations. Remedial Law. General Principles. Concept and Nature of Remedial Law. Remedial law refers to the rules which provide the system for the protection of rights, the prevention of violation of such rights, and the means of redress for such violations. Such rules also provide the methods for the enforcement of obligations recognized by the law and lay out the procedure by which suits are filed, tried, and decided upon by the courts of justice. As to the nature, rules of procedure are a fundamental part of a judicial system. They act as a vital link that connects the domain of substantive law with that of judicial administration. Remedial law or the rules of court promulgated by the Supreme Court have the force and effect of law, if not in the conflict with positive law. B. Procedural laws applicable to actions pending at the time of promulgation. Rules of court are not penal laws, hence no retroactive effect, but rules of procedure may be made applicable to actions pending and undetermined at the time of their passage, there being no vested rights in the rules of procedure and deemed retroactive in that sense or extent. The 2019 amendments to the Rules of Civil Procedure shall govern all cases filed after their effectivity on May 1, 2020, and also all pending proceedings, except to the extent that in the opinion of the court, their application would not feasible or would work injustice. Rules of court should not be applied to override substantial justice. The procedure under which cases were filed shall govern. In criminal cases, changes do not retroactively apply if they permit or require a lesser quantum of evidence to convict that what is required at the time of the commission of the offenses, because such retroactivity would be unconstitutional for being ex post facto under the Constitution. C. Construction of procedural law rules. How should the rules of court be construed? The rules of court shall be liberally construed in order to promote their objective of securing a just, speedy, and inexpensive disposition of every action and proceeding. A liberal construction of the procedural rules is proper where the lapse in the literal observance of a rule of procedure has not prejudiced the adverse party and has not deprived the court of its authority. D. Rulemaking power of the Supreme Court. Article 8, Section 5 promulgate rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts, the admission to the practice of law, the integrated bar, and legal assistance to the underprivileged. Such rules will provide a simplified and inexpensive procedure for the speedy disposition of cases, shall be uniform for all courts of the same grade, and shall not diminish, increase, or modify substantive rights. Rules of procedure of special courts and quasi-judicial bodies shall remain effective unless disapproved by the Supreme Court. The Supreme Court explained in Echegaray versus Secretary of Justice and Estepona versus Lobrigo in 2017, the rulemaking power of the Supreme Court has expanded. It has given the power to disapprove rules of procedure of special courts and quasi-judicial bodies. But more important is the Constitution removed the power of Congress to repeal, alter, or supplement rules concerning pleading, practice, and procedure. It is no longer shared with the Congress, more so with the executive. SC has the sole exclusive prerogative to amend, repeal, or establish new rules for a simplified and inexpensive process and the speedy disposition of cases. E. Classification of Philippine courts. Philippine courts are classified based on the following. Number 1, regular courts such as the Supreme Court, Court of Appeals, regional trial courts or the second-level courts, metropolitan trial courts, municipal trial courts in cities, municipal trial courts or municipal circuit trial courts as the first-level courts. Special courts such as the Sandigan Bayan, Court of Tax Appeals, Sharia District Courts, Sharia Circuit Courts. As for the quasi-courts or quasi-judicial agencies such as, but are not limited to the following: Civil Service Commission, Commission on Elections, Commission on Audit, Securities and Exchange Commission, and National Labor Relations. F. Hierarchy of courts. Under this doctrine, where courts have concurrent jurisdiction over a subject matter, such concurrence jurisdiction does not grant the party seeking relief the absolute freedom to file a petition in any court of his choice. Pursuant to this doctrine, a case must be filed first before the lowest court possible, having the appropriate jurisdiction, except if one can advance a special reason which would allow a party a direct resort to higher ground. Ground allowed for immediate resort to Supreme Courts are the following. Number 1. When genuine issues of constitutionality are raised that must be addressed immediately. Number 2. The case involves transcendental importance. Number 3. The case is novel. 4. When the constitutional issues raised are better decided by the Supreme Court. 5. When time is of the essence. 6. When the subject of review involves acts of a constitutional organ. 7. When there is no plain, speedy, and adequate remedy in the ordinary course of law. 8. When the petition includes questions that may affect public welfare, public policy, or demanded by the broader interest of justice. When the order complained of what? 9. When the order complained of was a patent nullity. And number 10, when the appeal was considered as an appropriate remedy. Pursuant to this doctrine, a case must be filed before the lowest court possible, having the appropriate jurisdiction, except if one can advance a special reason which allow a party a direct resort to a higher court. In the Book of Riano, a disregard of this doctrine is equivalent to denial of petition. It is a constitutional imperative, not a matter of mere policy. Given 1. The structure of our judicial system, and 2. Requirements of due process. Letter G. Doctrine of non-interference or judicial stability. The doctrine of non-interference or judicial stability dictate that a trial court has no authority to interfere with the proceedings of a court of equal jurisdiction, much less to annul the final judgment of a co-equal court. The orders and decisions of a competent court cannot be altered, modified, or amended by another court of concurrent jurisdiction.